I'm Andrea Miller. I'm a visiting assistant professor of psychology at the University of Illinois. Today I'm going to be talking about the work I've been doing with state judges and some of the rewards and challenges of that work along the way. So first, a little overview of the project. In 2015, I was postdocing at the American Bar Foundation, and this particular state court approached ABF and asked for some social scientists to help them do a study of bias among judges. So it was very lucky. I just happened to be there. This project fell in our lap. And the folks at ABF, specifically Bob Nelson, who was a past president, said, Andrea Miller's a social psychologist, she could do this with you. So I was extremely lucky to have that opportunity arise, and so I jumped on it right away. But it's an important thing to note for this study that it was the state court system itself that asked for this project and wanted data. They intrinsically care about evidence-based policy in this particular state, so that is kind of going to be a running theme of my talk, that has been really important for the success of many of the phases of this project. So the only kind of parameters that they gave me was they wanted to do a study of race, gender, income, and representation status biases. So that just means if someone's represented by a lawyer or not in their case. That was it. That was all the parameters. Everything else was up to me. So I took that and jumped on it and took the opportunity to pitch as big of a project as I possibly could get away with. So there were a lot of compromises and kind of scaling back that we made to the project from my original pitch, but actually most of what I asked for ended up going through. So I think thinking kind of optimistically and thinking big in this kind of area is really important. We spent a year developing the study alongside the Judicial Committee that had initially asked for this project. It was a subcommittee of the state Supreme Court made up of trial and appellate judges and a couple lawyers, and it was the Committee on Equality. So they had a specific mandate to address issues of inequality in the state. And so I was working with them to develop all these drafts of the study along the way. And that's going to become relevant a little bit later when I talk about challenges and lessons. And then in spring 2017, we officially launched the study. We managed to collect data from 2/3 of the trial judges across the state. So we have a really, really good sample of about 600 judges in a state that has about 900 at that trial court level. All right, so just to give an overview of what we were looking at in this study, we measured the judges' cognitive styles, so the extent to which they lean toward more deliberative or more intuitive decision making. We measured judges' gender ideology, their support for more traditional gender roles. We measured a race IET among the judges. We gave them 5 hypothetical cases with experiments embedded into those cases. So we experimentally manipulated race, gender, income, and representation status of the litigants in the cases, and then had them decide these cases. We also tested a couple of interventions, kind of a rough, really quick intervention that we could just stick in for 30 seconds at the beginning of the study. 1/3 of the judges were told, as you decide these hypothetical cases, keep in mind that as a judge, you are accountable to others for your decision making. You're accountable to appellate courts who might be reviewing your work, and you're accountable to the public. So that was our accountability intervention. Another 1/3 of the judges were given the deliberation intervention. They were asked, as you're deciding these hypothetical cases, please work through them as deliberatively as possible. Don't rush to judgment, but really think through them step by step, and take your time and take notes if you need to. And then there was another 1/3 of the group that was a control group with none of these interventions. We also measured some of the working conditions that judges are experiencing in their courtrooms, things like heavy caseloads, the need for multitasking, threats to personal safety, having to learn broad case types and learn many different areas of the law, all of those kinds of working conditions that might interfere with good decision making. And then we measured some demographics. Now, the demographics were one of the areas where I really had to compromise because it was really important to these judges that the data not be identifiable by anyone. I already have an agreement with them where I can't share the data with anyone. But in case of being hacked or some kind of data breach, it's really, really important that these judges not be identifiable in the data set. So, for example, instead of asking them their age, they had to report their age within 5-year blocks. age 35 to 40, age 45 to 50, whatever. Instead of asking exactly which courtroom they work in, I could ask which of the 5 appellate districts their court sits in. So I could break them down into a fifth of the state, but no more of a refined geography than that. So basically all of our demographics kind of look like that, where I had to make pretty major compromises. That also meant, because these people aren't individually identifiable, I can't go back and look at the correspondence between their data in this study and their actual real cases that they've decided. That was one of the big things from the beginning that I had wanted to be able to do. That was probably the biggest compromise that I had to make in this study. But it's important to compromise. So we still got all of these amazing measures in there. So just to give a very fast overview of the findings before I talk more about the policy work. Not surprisingly, we found that judges' cognitive styles and race IAT scores resemble the general population, in that there's a lot of variation between individuals and there's a lot of negative racial associations among the judges. That's not surprising to us as social psychologists, but that is very, very surprising to this sample. This is a group of people who have been socialized throughout their legal education and their career as attorneys, and then especially their career as judges, to believe that they are super rational, kind of superhuman decision makers whose job it is to be unbiased. Many of these judges see it as actually a professional failing or a moral failing if they accept the idea that their decision making might be biased. And so getting over that idea has been one of the major projects involved in this project. Judges rated their abilities to avoid race and gender bias higher than any other judicial skill. So when we asked them, literally rate your knowledge of the law, rate your ability to manage the courtroom, rate your ability to judge the credibility of witnesses, they rated those abilities lower than their abilities to avoid race and gender biases. Of course, that did not match the results that we found, which I'm going to show you here. So in our hypothetical cases, we found that case outcomes were influenced by litigant race. So if you gave the judges exactly identical cases and just changed the race of the defendant or the plaintiff, that had an effect on case outcomes. Racial IAT scores correlated with case outcomes in a lot of cases. Litigant gender had an effect in a lot of the case outcomes, and the judge's own gender ideology had a pretty strong correlation to case outcomes that were related to gender roles. We found some small effects for litigant socioeconomic status in just a couple of our cases, but it wasn't a really consistent finding. It wasn't as strong as race and gender. And the same thing goes for representation status. There was a couple findings here and there where representation status mattered, but it wasn't as strong or consistent of a finding. As for our interventions, we found that the accountability intervention did not work. In a couple cases, it actually appears to maybe have backfired, where the case outcomes had bigger disparities in the accountability condition than the others. But our deliberation intervention shows promise. So everything we've done since then, and you'll see that in the policy reforms that I talk about, is kind of focusing on this deliberation idea. Expertise and specialization of the judges was associated with greater disparities in case outcomes, not less. So the more a judge had expertise in a particular area of case law, or the more they specialized in that area of case law, the greater race and gender disparities they exhibited in their case outcomes. I was expecting the opposite. So that finding has been by far the biggest finding, that's been the most generative for me as far as producing actual peer-reviewed research papers and future grant applications and things. And finally, our judges experience a lot of working conditions that create barriers to deliberativeness and good decision-making, things like time pressure, multitasking, some of those factors I talked about earlier. Okay, so what have we actually done with these findings since about 2017? First of all, there's been a large number of educational initiatives that we've taken on. So because of my role in the study, the chief judge that I was kind of working with, we were sort of partners in this whole project, have been asked to teach a lot of courses to various groups of judges in the state on the topics of bias and implicit bias, using this study data as a kind of motivating content for the judges to really care about this issue of bias. So it's been really powerful to have that data. Until we did this study, I could speak to these judges and say, psychologists have found that implicit bias or racial bias or gender bias have huge effects on decision making. That's a really big problem. It's probably a problem for you too, right? But they didn't believe me because these judges tend to believe that they're immune to these sorts of biases. And honestly, people in general population often believe they're immune too, right? So that's not really a judge problem, that's an everyone problem. But having the data from this state saying, look, you were participants in this study, I can show you the biases that you all have, has been really, really powerful in getting them to pay attention to all these new educational initiatives. So we've done things like the biennial Judicial Education Conference in this state. This is where the judges get their continuing judicial education credits for the most part. They just take a week off from judging, go do all of their coursework for a whole week, and then they're good to go for the next 2 years in terms of their hours. We've done courses on bias at these education conferences. We just created a new course on bias for the new judge training. So once a year, there's a training for every judge that took the bench that year. And so we're really focused on starting to kind of educate these judges really early in their careers about these issues so that they can continue to think about them in an ongoing way. Specific districts within the state and some particular subgroups of judges and other judicial partners have asked us for specialized training sessions for them. So kind of in an ad hoc way, I've also been teaching self-represented litigant coordinators, groups of chief judges, the peer evaluators, the judges who are going to be actually evaluating their peer judges for performance evaluation every other year, and the mentors who are mentoring new judges. So we kind of wanted to get our tentacles in lots of different groups of judges throughout the state so that these messages about bias and bias reduction are kind of coming from all sides. As for policy reforms, so in addition to those educational initiatives, we have also gotten this particular state Supreme Court to define bias awareness as a core competency for judges. So now it is officially legally defined as a job requirement that judges have to care about this. We got the state to institute a minimum requirement for continuing ed hours on bias and diversity content. I believe they have to do 30 hours of continuing education every 2 years. 3 of those now have to be on the bias and diversity topics. And I personally, alongside my fellow co-judge partner, we got to sit down and actually write those definitions for what coursework counts, which was really important to us. We got the state to institute a new policy encouraging every educational convention course to incorporate content on bias. So it's not just the one course that's 90 minutes long that we teach throughout that entire week of coursework. That's voluntary, so not all judges go to it. But now we've got every single educational course, even on substantive topics, things like bankruptcy law or tax law or family law or whatever it is. We've got sort of a mandate out that all of those faculty members have to somehow incorporate discussions of bias into their educational content. And we spent some time actually personally being in the room and workshopping with them on how to do that. And along the way, as we've done all of these educational sessions, we've also been teaching judges and administrators how to identify potential reforms in their own circuits and districts. So we can't always be in every place identifying, hey, this new technology would help you reduce bias, or this new decision-making rule, this new sentencing guideline, whatever it is. But we're sort of teaching people to recognize when they might be more vulnerable to bias, what kinds of decisions might be more subjective and ambiguous and leave more room for bias, and what they could do to advocate for themselves to change those policies. Next steps for research, we want to take a closer look at that deliberativeness intervention, see if it's really working and what kinds of boundary conditions it might have. And we also want to look at some mechanisms for the expertise effect. I won't go in these in detail, but for example, I'm interested to know if maybe the judges with more expertise and more specialization are, for example, engaging in more heuristic processing. Maybe that's exacerbating these gender and race biases, or maybe they're more overconfident in their decision-making abilities. So those are the kinds of mechanisms we're going to be looking at. Next steps, we're going to take this outside of the state where this started. I'm going to be presenting to the American Judges Association and the National Bar Association this July, and I'm kind of going to be hoping but also working to make connections with judges and lawyers in all these other states who are there to try and expand this message outward and get the opportunities to collect data in other places. We are helping to write the new 3-year curriculum for the Judicial College that was just started in this state. So they're hoping to have a more systematized, kind of concretized curriculum for judicial education that will be on a 3-year rotation, and so we're going to help write the actual bias content of that course. We are advocating for specific policy reforms statewide. For example, some districts within this state use risk assessment software in their bond courts, so the software assesses the risk of a particular defendant based on certain relevant variables, skipping court, skipping bond. And some districts and circuits don't use that technology and just have judges off the top of their heads decide what amount of bail money is gonna get someone to come back to court. And you can probably guess which of those two systems produces a lot of race and poverty biases. And so, for example, when we've identified specific policies like that, where it would be really easy to institute a reform, some of the districts are already doing it, we just need to spread it statewide, we're kind of constantly advocating for those policies. We also want to expand all of this education to non-judicial justice partners, so guardians ad litem, probation officers, clerks. For me, the most rewarding parts of this project have included, first of all, some of the actual CV deliverables. I've gotten 2 articles so far out of this. Well, one's in late R&R stage, one's actually published. And hopefully there's more to come. And we've gotten material for larger grant proposals that are in the works and gonna be submitted soon. I've gotten a lot of research benefits out of this project. Just working with these judges day to day over the course of all these several years now, I've gotten a lot better idea of how the law really works in these areas. So I am a lawyer, I do know a lot about the law, but actually this project has given me a lot more on the ground, really kind of finite, concrete understanding of judicial decision making, and that actually affects how I design my research now. The project has also given me a lot of broader exposure. When I have these research findings, they're not just kind of getting buried in academic journals for like 25 people to see, but I've gotten some media press coverage and things around some of these judicial audiences. I also just get a lot of personal sense of mission and meaning out of this project. When I kind of was retrospecting back on this work to write this talk, it sort of occurred to me that the most enjoyable parts of my research, the most enjoyable pieces of my day or my work week each week are when I'm working on this project, and because I actually kind of realized it's a lot more fun to go out in the real world and talk to real people who these findings are actually affecting than it is to just keep writing more papers. And there's a lot less delay of gratification. There's a lot of little successes along the way that are giving positive enforcement, positive feedback and rewards. Getting to see these policy changes in action, getting to have a one-on-one conversation with a judge who kind of has a light bulb moment and I get to see them start to understand why this matters. It's just a lot more rewarding than waiting 2 years for a paper to get published. But all of that being said, there are some major challenges. It's really risky to invest so much time outside the university. The potential CV payoffs are really unknowable in advance. And especially because I am pre-tenure, it remains to be seen whether I'm spending too much of my time working with these non-academic partners rather than writing papers. I'm not sure, and there's not really going to be a way to know that until tenure time. And then it's really, really hard to pitch this research to psychology journals. I get a lot of kind of knee-jerk reactions from editors who see this work as just applied, not basic, not pushing theory. And I always get the, maybe this would be better for a specialty journal line in pretty much every submission. So that's something that's a constant struggle that you kind of just have to know going into this kind of work. I've been working really hard to show the theoretical contributions, like this expertise finding that I had, to kind of convince psychology journals that this isn't just applied work, it's actually pushing psych theory forward. And sometimes I have to actually downplay the legal and policy implications. Even though they're important and they're kind of what's most important to me about the work, sometimes I have to downplay the importance of that to convince a psychology journal that this is real science. So I don't have a lot of time. I think I've gone a bit over, so I'm just gonna go through this really fast. Lessons learned. I had to listen a lot to my judge partners during the early stages of this project, both so I could learn how to deliver a research project they could actually use, research findings that aren't just good for journals, but that they can actually act on, and learn how to tailor my pitches to their concerns. They're concerned about things like, people are gonna think I'm biased and I'm gonna look like a bad judge. I have to be able to talk about the importance of the project, keeping that concern in mind. It takes a lot of time to teach scientific concepts to a non-academic audience and to communicate in their language. Luckily, my legal education helps me somewhat with that, but I have to continually remind myself that re-explaining why a control group might matter, for example, is really, really necessary. It's really important to get buy-in from community leaders. If I go into some of these courses and start talking about the importance of bias and implicit bias reduction, I don't have a lot of credibility in a room full of judges, so I have spent a lot of kind of careful strategizing to make sure that that message is more often coming from a fellow judge that's within the community, and that I'm just standing alongside that judge as a partner, so that it's just way more effective than if that message is coming from me directly. And being mindful of multiple perspectives within the community. So there's multiple audiences here. I've been talking about judges like they're one group, but actually there's judges who are really, really excited about this work and care about it a lot and are devoting their careers to solving these problems. There's judges who think social scientists are all biased and evil and the idea of implicit bias is offensive. And then there's judges all along the spectrum in the middle, right? And so I have to be able to communicate with all of those different subgroups. And finally, there's so much luck involved in this kind of work. Opportunities arise just randomly. You don't expect when they're gonna happen. So I've learned to just kind of say yes to every proposal that they make so that I can keep my relationship with this state group going. And that has continued to open more and more doors for policy reforms along the way. All right, thank you to my partners.